Today we have two speakers with us, Barry Williams and Marcus Reinhardt. Barry is an architect and he's licensed to practice in California and Ohio and has over 45 years of diversified experience in the design, project management, and construction management with a wide variety of private sector residential, industrial, medical, and commercial projects, as well as state industrial and educational projects and federal government projects. Barry is currently serving as a subject matter expert consultant to the California Architects Board and has 9 years of experience working for the board's enforcement unit. So that was Barry. And our second speaker is Marcus, who is a manager of the licensing program of the board. And Marcus has 15 years of expertise in architectural licensing with the board, as well as 10 years as program leadership. And Marcus also has 5 years experience as an NCARB licensing advisor as a board representative. And Marcus also focuses on modernizing licensure and reducing barriers. So welcome, Barry and Marcus.
Okay.
Thank you.
Thanks, Jane. Good afternoon. And on behalf of the California Architects Board, welcome to our presentation of working with the board. I'm Barry Williams, and Marcus Reinhardt's here with us. And what do we do for the board? What do we do for the board? As a subject matter expert, it's my job to help architects and architect candidates, as well as building officials and contractors, etc., better understand the Architects Practice Act, its rules and regulations. I also provide technical advice and professional advice to the board staff. And as a subject matter expert, I've helped resolve over 500 consumer complaints. Marcus manages the board's licensing program, as you've heard, and we both work together to make presentations to help professionals and candidates for licensure stay out of hot water with the board. That's our purpose. Yeah. Okay, our agenda. Part one, actually, it'll be in 2 parts today. I'll be presenting the California Architects Board presentation for the who, the what, and the why of the board. I'll be talking about the California Practice Act, the regulations which govern the practice of architecture in California. And we'll be talking about the do's and the don'ts, the things that you basically want to do or do not want to do to stay out of hot water with the board. We'll be talking about board concerns, and these are the things which the board needs to communicate to architects and also candidates. We'll be talking about board publications and resources available to licensees. And then we'll have a question and answer period. Now, part 2, Marcus will be talking about becoming an architect, and we'll be talking about the requirements for eligibility, the process, board publications and resources for candidates, and questions and answers. Our rules of engagement today are pretty simple. We'll be recording this session, and that's primarily to help me do a better job next time. And we'll be talking about polling questions. So please participate in our polling question exercises. That helps us better understand your interests and your level of understanding. And when you have questions, just feel free to jump in and ask your questions. And what we promise is that if we can't answer your question when it's asked, we'll get back to you with an answer. Okay, our first polling question is, who are you? And Jane, I suspect that you're sending out the polling question now. Well, we've got about 10 responses, and it looks like the majority of the folks are architects. We do have a couple of candidates for licensure, which is good. Thank you for participating with us. Okay. And I guess, Jane, I can get rid of that now?
Yes.
Okay. All right. Let's talk about the California Architects Board. The Architects Board was founded in 1901 by the state legislature. And the board was founded primarily to protect the public health, safety, and welfare. That's the purpose of the board. And the board consists of 10 members, 5 architectural members or architect members, and all members of the who are architects are appointed by the governor. And we have 5 public members, 3 members appointed by the governor, and 1 each by the Senate and the Assembly. And the mandate for the board as an agency of the Department of Consumer Affairs is to protect the public health, safety and welfare through examination, licensure, and regulation. Let's talk about the Practice Act. First of all, only architect licensees are authorized to practice architecture in California. And the term practice is defined, and I quote, offering or performing or being in responsible control of professional services, requiring the skills of an architect in the planning of sites and the design of buildings in whole or in part of buildings or groups of buildings and structures. Now, this is important because it defines what an architect can do. And in just a few minutes, we'll be talking about when building officials question your ability to or your right to design certain buildings. This is an important item to remember. And the Title Act. The Title Act is also a very important part of the Practice Act. And only California licensees are authorized to use the title architect. And it's a misdemeanor for unlicensed persons to use the title in any way, shape, or form, which is confusingly similar with the term architect. For example, architecture, architectural, when representing themselves or their qualifications in including the title architectural designer. So it is important to note that as a candidate for licensure, you can't refer to yourself or represent yourself as an architect. Here's our next polling question. Are you familiar with the rules and regulations of the Practice Act? It's a pretty simple question, but I think we're going to get some surprising results. Oh, actually, I'm impressed. It looks like the 7 folks, and probably these are the licensed folks, are familiar with the Practice Act. That's good, because in many cases, when there is a complaint filed against an architect, the question is asked, are you familiar with the Practice Act and the regulations and the rules that correspond to the complaint? And in many cases, the answer is no, which is very unfortunate. And I'm going to give you another question, I think that's kind of important. When was the last time, let's see, when was the last time, let me get rid of that. Okay, here's our next polling question. When was the last time you read the Act? Now, again, I think it's important that that you not only know that the Practice Act exists, but that you're that you're familiar with it, and you're familiar with the rules and regulations associated with the practice of architecture. And it looks like it's been a while for some folks, and some folks have never looked at it. So I would caution you to be familiar with the Practice Act, and we'll talk more about that when we get under when we take a look at the resources available to licensees and to candidates as well. Okay, let's get rid of that. Okay, let's talk about the do's and don'ts. As I had mentioned before, there are at least 380 reasons why you need to be familiar with the Practice Act. And that essentially boils down to in the fiscal years 2017, 2018, the board received approximately 380 complaints. And the board issued 157 letters of advisement as a result of those investigations and cited 54 folks for various reasons. Fines were assessed in the amount of $36,000. So it's very important. Now there are about 21,000 architects in the state of California. So 380 represents just about 2% of the population. And it may not seem like a very big portion of the population, but if you're in that group, it's important. And that's really why we're talking to you today, so that we can maybe help you stay away from having to discuss complaints. It's been my experience that complaints are typically filed by first-time residential consumers, contractors, and other design professionals. And the allegations typically include negligence, willful misconduct, aiding and abetting, unlicensed practice. And there are other common complaints that also come to play, and typically those more common complaints tip the scale and cause complainants to file complaints of negligence or willful misconduct or whatever. Let's talk about negligence. Negligence is grounds for disciplinary action, and disciplinary action can include letters of advisement, suspension of licenses, or revocation of licenses. So it's a big deal. Negligence is when an architect fails to meet the standard of professional care. And my next question is, what is the standard of professional care? Well, it looks like at least one person believes that perfection is not the standard of care, which is true. But the standard of care, according to the AIA, is that level of skill and care employed by architects practicing in the same or similar circumstances and the geographical area. So the right answer is all of the above. But it's really, let's see here. Let's get rid of that. Let's talk about the standard of care. The board's definition of the standard of care is when practicing architecture, an architect shall act with reasonable care and competence and shall apply the technical knowledge, skill, which is ordinarily applied by architects of good standing, practicing in this state under similar circumstances and conditions. So that is the standard of care that we're all judged by. And if heaven forbid you're required to go to court for any reason, that's the standard that will be applied. Now, the standard of care, according to the AA, as I have mentioned, is a little bit less restrictive, but it's still very much in the same vein. Willful misconduct. Willful misconduct is grounds for disciplinary action, and willful misconduct is when an architect knowingly violates the law. For example, when an architect has full knowledge that his conduct or omission is a violation of the client-architect agreement, or when an architect knowingly violates building laws, codes, or regulations. So willful misconduct is a more serious violation than negligence, but it's important. Willful misconduct also occurs when an architect signs and stamps instruments of service that are deficient, or accepts payment for services that are not rendered, or when an architect abandons a project after receiving payment. Aiding and abetting. Aiding and abetting is also grounds for disciplinary action. And it's when architects sign and stamp instruments of service which they didn't prepare or exercise responsible control over. And also note that immediate and responsible control is when an architect instructs the persons that's preparing the documents, and the architect has exercised the same judgment and responsibility in reviewing all phases of the development of the construction documents, just as if the architect had personally performed the various actions required. Unlicensed practice. Candidates and architects who've not renewed their licenses in a timely manner must avoid practice without a license or misrepresentation. The board investigates all actions, all allegations of unlicensed practice, and may issue citations and administrative fines accordingly. So be cautious when using any form of the A word to represent yourself or your work or any qualifications. And the threshold for violation of the A word might indicate to the public that you are an architect or qualified to practice as an architect. So that's important. And if you have questions, contact the board and work with exempt project types only if you are unlicensed. And exempt project types include projects, for example, that utilize conventional wood frame construction and are not more than 2 stories in a basement in height, and include single family dwellings, multiple dwellings containing no more than 4 dwelling units, garages or other structures, agricultural ranch buildings. And please note that the design and construction documents for any portion of any structure that deviates substantially from compliance with Title 24 conventional wood construction has to be prepared by or under the responsible control of an architect or licensed professional engineer. So also exempt project types include tenant improvements. Here again, the Act does not prohibit any person from preparing design and construction documents that are non-structural or non-seismic in nature, which include storefronts, additions, fixtures, cabinets, projects of this nature, and the work necessary to provide for their installation. Also includes alterations or additions to any building, provided those additions do not change or affect the structural system or the life safety of the building. Local building officials act as the ultimate arbitrator of exempt versus non-exempt project types. Also, if you're an architect designing a non-exempt building, you cannot take off your architect's hat when preparing or being in responsible control of the design of these types of projects. So you're an architect no matter what, whether it's exempt type projects or not exempt. Now, other common complaints that can result in board actions include failing to listen to client needs. Now, most architects have experienced, when working with clients, various requirements, but it's these are the things, these are the common complaints that typically lead to more serious complaints of negligence or willful misconduct. Things like ignoring the project budget, failing to meet schedule requirements, failing to return calls or emails in a timely manner, essentially failing to communicate. So it's really it's important. Uh, Failing to communicate is so important. Next polling question is, oops, let me go back to that one. Can you identify other allegations or common complaints that you've experienced? Okay. Well, what can we do to help prevent the issuance of a complaint? Well, I recommend following the golden rule. Treat your clients the way you want to be treated. Learn to say no. Offer alternatives. Participate in the construction process. Since instruments of services, and especially those used for construction, are subject to interpretation, it's important to participate in the construction process. And I strongly recommend that you be there to help solve the issues before they become problems. So participate in the construction process and communicate. I can't stress enough the idea of communication. In many cases, the basis for a lot of complaints that I've reviewed are just simply the lack of communication. And probably the best advice I can offer you is if the board gives you a call, don't answer the call. No, just kidding. If you do receive any correspondence from the board for any reason, be prepared to answer the board within 30 days and be able to provide appropriate documentation to support your responses. And again, the key word here is document. Document your project files so that you are able to respond to conditions or allegations of complaints. Written contract elements. Written contract elements, there were 5, now there are 8. And the first one that is new is the description of the project for which the client is seeking services. Now, the second element of the contract is description of services to be provided by the architect. That's pretty much of a standard. Next is description of services. Oh, wait a minute here. I'm sorry. Description of any basis of compensation and method of payment agreed upon by both parties. Again, that's an original requirement. Name and address and license number of the architect, name and address of the client. You'd be surprised how many architects fail to put their license number on an agreement. And that is, you could receive a letter of advisement or be fined for something like that. Number 5, description of the procedures that the architect and the client will use to accommodate additional services and changes. That was one of the original comments. Description of the procedure to be used by either party to terminate the contract. A statement identifying the ownership and use of instruments of service prepared by the architect. Now that's a new requirement, as well as number 8, a statement in at least 12-point type that reads, and I quote, architects are licensed and regulated by the California Architects Board located at 2420 Del Paso Road, Suite 105, Sacramento, California, 95834. So the board is telling you on your license, you have to identify the fact that you are licensed and you're regulated by the board. More board concerns concerning the written contract. There are exemptions to having a written contract. First one is pro bono services. If you're doing a project where there's no compensation expected or required, you do not need to have a contract. Continuing relationship when compensation, the basis of compensation, and the services are similar to those previously rendered to and paid for by the same client. In other words, when you work with the same client under the same conditions, typically there's no requirement for a contract. Or the client knowingly states in writing after full disclosure that a written contract is not required. Or professional services rendered to a professional engineer or land surveyor. And the last one is professional services rendered by an architect to a public agency when you use that agency's written contract. Now, let's take a look at recommendations, my recommendations concerning written contracts. First of all, always work with a executed contract, and that includes, in my opinion, pro bono work or any work, even when you're working with a client on a similar situation for similar compensation, because you never know what the client's interpretation of that scope of work is. Be clear. Address the issues of budget and schedule, and document in writing all changes to the scope. So these are the things which basically an architect who is in responsible control of the design services is responsible for ensuring that all board written contract requirements are included. It's important. It really is. And the AIA standard form of design contracts are, and I know many architects use the AIA standard form of the contract, but always include your license number in the contract, primarily because the AIA version of the contract does not require the California architect to provide his license number, but that is a requirement of the board. Signing and stamping documents, another concern. Unlicensed persons shall sign all of their instruments of service. So as an unlicensed candidate, for example, when you design an exempt project, you need to sign your instruments of service. A licensed person, on the other hand, needs to stamp and sign their instruments of service. And that includes exempt project types. Now, why is that? Why does the board require stamping and signing or signing of instruments of service? Well, it's to provide evidence of responsibility for development of those documents. And the board does not specify or define the method of affixing one's stamp or signature, but the board does allow for electronic stamping and signing of instruments of service. Now, this is an example of stamping. Now, most licensed architects are very familiar with the architect's stamp, but for those of you that are candidates, need to be aware that these are examples of acceptable architect stamps. And stamps can be purchased from any source, and stamps can be no less than 1 inch or no greater than 2 inches in diameter, and the renewal date needs to be included on the stamp. Name and address of record. Now, this is a board concern that is very important. The architects are required to immediately notify the board of any change in their name or mailing address. And the business entity reporting form. Now, this is very important as well. Architects are required to provide the board with a name and address of the business entity through which they're providing their services. And BERFs can be found at www.cab.ca.gov, and just look under forms and publications. So my next question is, have you filed your BERF with the board? Or how many of you know what a BERF is? There are 5 folks that have not filed a BERF with the board. Now, we're talking about licensed folks here, so unlicensed people are not required to file BERFs, just the licensed folks. So please go to the website, the board website, and complete that form and fill it out. Business entities. Let's talk about business entities. The Practice Act provides for the following business type entities that an architect can provide services under: sole proprietorships, partnerships, corporations. And there are 2 forms of corporations that that an architect can use to provide professional services. The first is the general business or common stock corporation. And this is the most common form of business entity for architects to provide services in California. Also, professional corporations. Under the general business or common stock corporations, there is no ownership criteria, and there's greater name flexibility. And that's probably why most architects opt to form general business corporations. Now, limited liability partnerships are also allowed, and under a limited liability partnership, all partners must be licensed to practice architecture, and at least one partner must be licensed in California. Now, limited liability companies, the LLCs are not, well, let me go back to that. LLCs are not authorized to provide professional services of any kind in California. And really, before you form a partnership or a corporation, it's probably, I would advise you to talk with the California, the Secretary of State office to make sure that you're in compliance with their requirements. But again, sole proprietorships work, partnerships work, corporations work. Limited liability companies do not work in the state of California. And the A word. It's unlawful to use a business name that includes any form of the A word in the title or description of services unless an architect is in management control of the services offered and provided by the business and is either the owner, an owner, or an officer or an employee. Responsible control. When using a business name as described above, all services offered and provided are to be accomplished under the responsible control of an architect. The Practice Act also protects architects. In many cases, an architect may call the board and ask the board, what do you do for me? Well, as I had mentioned previously, the board's purpose is to protect the health and safety and welfare of the people of California. However, the Practice Act also protects architects, and it does so by unauthorized changes. It protects architects who sign and stamp their instruments from subsequent unauthorized changes that are made to your documents. So you are protected. Practice. General provisions of the Business and Profession Code prohibits any local government official, building official, from limiting the license authority of a state issued license. And this is what I was talking about before. If your license is questioned or your ability to design a specific type of project by the building official, that is not valid. And you go back to the definition of the practice of architecture, which allows you to design buildings in part or in total. So in many cases, you can convince the building official that yes, you are allowed to design specific type of projects comparable to, say, for example, a professional engineer. And I think the only restriction, in fact, I know the only restriction against architects practicing is that architects cannot provide the structural calculations for a hospital, but you can do everything else, and you're exempt from the professional engineers code to be able to do that as well. Now, the board also protects architects by investigating and addressing malpractice and unlicensed practice allegations. So, and as I mentioned before, the board does a very good job of responding to complaints and it makes every attempt to address every complaint. License renewal requirements. Marcus, I think you might want to take this.
Before you start, we've got a whole bunch of questions in chat that would be good to address.
Oh, absolutely.
We have from Jeremiah, I've noticed that roles in Silicon Valley using the term architect, for example, software architect. Does the Title Act comply with companies and their titles?
Okay, let me make sure I understand the question. You're saying that when the architect or the term architect is applied for other purposes like software purposes, that the Practice Act applies to that? Am I understanding the question properly?
Yes.
Okay. Well, the Practice Act is related to architects and not to other professions, so to speak. So the term architect, software architect, may not be in strict compliance with the Practice Act, but it's probably not, the Practice Act would not prohibit that.
Okay, we got another question from Rona. In work that we do for AIA California to address practice-related concerns and issues, among the most pressing questions is the concern about potential risk to public health, welfare, and life safety as a result of the exemption, which allows certain types of work to be performed by unlicensed individuals. Can you address this?
Well, yeah, the work that can be designed by unlicensed persons are the exempt projects that I talked about. And those exempt projects go back to single family residence, multiple family residence of a maximum of 4, ranch type facilities. Generally speaking, buildings that comply with Title 24 building code compliance for wood frame type construction that's defined in the code. So you're limited to those types of non-exempt type structures. Did I answer that question properly?
Well, hi, Barry. This is a good presentation. So I guess the question we've gotten, but it might be beyond the scope of this hour, is that even though the exemption in the statute for TIs was written wisely, does it really encompass the appropriate issues about elements that are impacted by seismic forces and fire and life safety? And shouldn't the code, since the code now requires that most elements of tenant improvements involve seismic forces and involve addressing fire and life safety, could you conclude that persons who don't have the rigorous education should not be designing those kinds of things? It's rather rhetorical, but it's still an important takeaway from that particular provision 5538, planning or design affecting safety of buildings, non-structural storefront and interior alterations. Thank you.
The answer is yes. If the building or the project includes any sort of effect on the life safety of the building or the life safety of the facilities or the seismicity of the facility, then an unlicensed person cannot design that type of structure. Only a licensed architect is allowed to design that type of facility. So yes, thank you. That's a very important question, because that comes about under unlicensed practice, and in many cases, what happens is that people believe that they can, in fact, do that type of work who are not licensed, and they go ahead and do it, and then the building official will say, "Wait a minute, where's your stamp?" And that creates a lot of difficulties, and typically results in complaints because the client has paid money and expects certain services to be performed, and when the individual who's performing those services is not aware of the requirements, it can get it can become unpracticed without, or unlicensed practice. So, any other questions?
Sure. We've got another one from Young Lan. When a designer, not a licensed architect, acts as the person in responsible charge for an exempt project and invites a licensed architect as a non-lead coordinator, is the licensed professional putting themselves in a position of risk when something goes wrong with the project?
Gosh, I would say in a court of law, probably, because when you're licensed, you are expected to meet certain standards. However, getting back to the question, it sounded like the architect was providing consulting services for, did I understand that properly, lead work? And he would be responsible for whatever services that he provides as a licensed architect. So even though it's an exempt project, as I mentioned before, the architect cannot take off his architect's hat. He is responsible and functions as an architect, whether the project is an exempt or not exempt project. Does that answer the question?
I think so. We got a couple more.
Okay.
From the Business and Professions Code, section 5537 allows unlicensed persons to design certain types of structures, including single-family residence of wood frame construction and barns, for example.
Mm-hmm.
Collaboration between a licensed and unlicensed designer is permitted by statute. It would be unusual for the licensed architect to be bought on, but not in a reasonable control. So I guess this is the answer that Mike was answering that previous question.
Yes.
Very good. Thank you for jumping in.
Thanks, Mike.
Got one from Daniel. Why is an LLC not allowed if it's just a tax structure?
An LLC is by the Secretary of State, by determination of the Secretary of State, is not allowed. And the reason behind that is it's more of a legal condition, And that there you'd have to talk with the Secretary of State's office to find out why. They're the ones that have made that decision. It's just I guess the only thing I can say is you cannot provide architectural services through an LLC. But the reason
Also,
behind that,
graciously added some detail there, so you guys can grab the corporations code section that he added to that section. Last question for now from Jacob: should architects stamp non-design documents such as a building assessment report, preliminary cost estimate for due diligence?
as a matter of fact, yes. The answer is yes, because the way the Practice Act reads is that an architect is responsible for stamping and signing all instruments of service. And if that instruments of service includes say a written report, for example, yes, he stamps and signs that document as well. So it's all instruments of service. But traditionally, an architect will stamp and sign documents as engineers do at the point when they're submitting the documents for plan review. But it really doesn't stop there, and it really starts with, for example, the first report that the architect does, say on ADA compliance. If an architect is required to provide a report to his client, he should stamp and sign that document. Are there any other questions? Hello?
No, there are not.
Okay. Marcus?
Hey, so
if there are no more questions, carry on.
okay, so I'll pick up here for license renewal requirements. So for the architects in the audience, they renew their licenses every 2 years in the odd years. One of the conditions for license renewal is the completion of 5 hours continuing education on disability access requirements. And that's to be done in the previous 2 years. Coursework is specified as disabled access requirements, specifically Americans with Disabilities Act, state and federal laws that also relate to those laws, regulations as well. Licensees are required to maintain those records for at least 2 years, as licensees are subject to an audit. The licensees who fail to take the continuing education, they may be required, they may receive a citation or an administrative fine. Now, just in September 2020, AIA California proposed additional continuing education requirements, this on zero net carbon design, and they're being explored by the board at present. We have a complete list of the licensing requirements on our website, but essentially this summarizes it.
Board resources and publications. If you go to www.cab.ca.gov and then general information / publications, these are the documents that are available to architects, and of course there are others, but the Practice Act is there, the current Practice Act is there. You can obtain the birth forms, change of address forms, and frequently asked questions. And this is, I think, very helpful because in many cases, architects will have questions that other architects have asked, and they've been published on the board's website. So if you go there, you probably will be able to answer that, have that question answered before you call the board and ask for an answer. The rules of conduct are there. retired licensee requirements are also posted. So I strongly recommend that as an architect, that you utilize the publications and resources available to you at the board. Okay, are there any other questions and answers that I can provide? Mike Wilson, do we have any other questions?
No questions at this time.
Okay. All right, Marcus, it's all yours.
Thanks, Barry. Becoming an architect. So individuals that are interested in becoming a licensed architect will start the process in generally the same way. The candidate has to provide evidence that they are eligible ultimately to receive a license. They have to meet the following requirements. First, you need to be 18 years of age or have equivalent to graduation from high school. Next, you will need to document with the board 5 years of architectural education and training or the equivalent. Next, you'll need to register for the Architectural Experience Program, or if you're from Canada, the Intern in Architecture Program. Next, you'll need to complete all of the divisions for the ARE, and then afterwards complete the California Supplemental Examination. So in looking at the various pathways, while essentially the requirements are all the same, there's different ways that people achieve those paths to obtaining a license. One way is through the NAB accredited degree. So it's a NAB, which is National Architectural Accrediting Board program. Those programs or the Canadian Architectural Certification Board program, they are considered the same by California laws and regulations. That's one of the more common paths that people take. Another more common path that people take is getting a degree such as a Bachelor of Science in Architecture, or you could even have a degree in music or fine arts, and then supplementing that with work experience under the direct supervision of an architect. And it's important that it be under the direct supervision of an architect. A more recently added path is the integrated path to architectural licensure, which NCARB organized and developed a few years ago. That path combines an architectural education with the architectural experience program, the internship that's done there, and incorporates the ARE, so that while individuals are going through an accredited program, earning their experience in architecture, they can also take the individual divisions of the architect registration exam. And lastly is the good old apprenticeship path, or work experience only, where you're working directly under the supervision of an architect. Now, another way for individuals who are already licensed in another jurisdiction would be to come through reciprocity. And for reciprocity, individuals would meet those other requirements I previously mentioned, but for the most part, since they're already licensed, they're just going to take the California supplemental exam after they apply with the board. Successful completion of the exam will allow them to apply for the license. So how does one start the process? Well, first and foremost, an individual needs to establish an NCARB record and select California as their testing jurisdiction. That's very important. When the board is notified that you have selected us as your jurisdiction, you'll receive 2 emails. One email will come from NCARB, letting you know that you've selected California, and also advising you to check with the board for what requirements there may be. And for us, that would be completing the application for eligibility evaluation. That's the next thing that a candidate must do. You won't be activated for testing until we have your documentation, until you submit your application. So it's very important, once you've selected California as your testing jurisdiction, to file that application and have your documentation submitted. Now, of course, I mentioned the pathways. So you'll need to follow one of those pathways in order to receive a license. And at the end, you're going to complete, in the next part, you'll complete the ARE, all of those divisions, and then follow that with the California Supplemental Examination. You have a 5-year period in which to take an exam and remain an active candidate. And it's important to emphasize that if a candidate is currently active and becomes inactive, they're subject to the requirements in effect at the time they reapply. So for those who are exempt from AXP, for example, if your activity becomes inactive, then you would necessarily have to take the AXP. Another thing is that NCARB has the ARE rolling clock, wherein a candidate must take and pass all 6 divisions of the ARE within a 5-year period of time. Divisions such as construction management, program and analysis, practice management, project development and documentation, project management, and the last division is project planning and design. Those are what comprise the ARE now, under ARE 5.0. Individuals who have been in the testing process for a few years may have transitioned from ARE 4.0 into the current version of the exam, and in the future may transition to still another version of the exam. So on the next slide, if you're a foreign individual, if you're licensed in another country, one thing you can do is reach out to NCARB and become NCARB certified. That's typically how individuals will become licensed in California when they have a foreign license. If, on the other hand, you're not licensed in the foreign country, then, and you want to receive a license here, you would need to have either go through your foreign evaluation process for your degree and go through the apprenticeship path, work experience, or as I mentioned, you can go ahead and do NCARB certification if you're licensed. On the next slide, if you're licensed in California, within the US jurisdiction, then you'll have a few actions that you'll need to take, when you want to become licensed. First, you'll need to apply with the board. You'll complete a California Architect Reciprocity application. And then on the next action, you can have your NCARB, as long as your certificate is valid, you can have that transmitted, or you can provide us the documentation, such as documenting 8 years of pre or post licensure experience. It can be through solely work experience, or it can be a combination of work experience and education. Another thing that you can do, or that you'll need to do if you've been licensed less than 3 years, you'll need to provide evidence that you've completed AXP. In that circumstance, I'll let everyone know that NCARB requires an individual to be NCARB certified if they want a transmission of their AXP record once they're licensed. So in that case, if you've been licensed less than 3 years and you want to seek licensure here, it's best to have your NCARB certificate transmitted and follow that path. And your NCARB certificate will have all the information that we need in order to determine your eligibility to take the exam. On the next bullet, if you are licensed in another jurisdiction and your spouse is in the military and assigned to a duty station here in California, we have expedited licensing for individuals. It's important that a copy of the orders be sent to the board, and that it be, there's a box on the application that needs to be checked indicating that that's the situation. And then once we have that, the application will be expedited. It's important to know that it's any domestic union, marriage, or partnership, and the individual must be licensed in another jurisdiction. Expedited licensure will allow you to go through the process faster, but you still need to take the California supplemental examination before a license would be issued. On the next slide, fingerprints for applicants. So recently the board notified candidates of the requirement that begins on January 1st, 2021. Candidates who are active in the process now, but are not licensed on or before that, or rather before that date, will need to have fingerprints done before a license can be issued. And Mike, do you have anything to add to that? Oh, Mike Skenga?
Hi.
Sorry.
No, we do have some publications coming out with a lot more detail on those issues, and we'll see what happens when the new program starts.
Okay. We do have some polling questions, but so we can start with our first polling question. Have you established an NCARB record and selected California as your testing jurisdiction? Okay. So looks like the majority of you have established an NCARB record and selected California as testing jurisdiction. So that's great. As I mentioned, it's also important that an application for eligibility evaluation be submitted so that, and your documentation, so that we can evaluate it and authorize you to test. We have another polling question. Do you work in the field of architecture? Okay, so for those of you who are candidates, this is important because in order to become eligible to test, you have to work in the field of architecture under the direct supervision of an architect, that or have the accredited degree or have a combination of that experience under an architect plus some education. That working in construction, working for a landscape architect, working under an engineer, it can't be granted credit until after an individual has either has done an accredited program or has achieved 5 years of work experience under an architect. And then one more polling question that we have for everyone. Have you taken at least one ARE division? So it's great to see that the majority of those who responded have taken at least one ARE division. Now, in the chat, do we have any questions in there that people would like to have answered?
I tried to answer one about whether there's a Mexico equivalent of NAAB and CACB. And I answered that there's some information about the education evaluation services for architects with foreign degrees on our licensure pathways website.
Yeah, I am unaware of any organization similar to NAB or the CACB for Mexico. There are on our website foreign evaluation services. Just search in our search bar for that. It's under candidates. And that can help as far as California goes. NCARB is very specific. For them, you must have an ESA, which is an Education Evaluation Services for Architect evaluation. For the ESA, it is an all or nothing as far as the credit that we can grant, because as ESA is established, you either meet the requirement, the NCARB requirement, which is an accredited degree, or you have deficiencies that must be corrected. So if you're just looking to register with California, you may want to look into one of those other services. If you are, however, considering NCARB certification right away, then it's highly recommended that you go with ESA, since that's all that NCARB will accept. I am looking now in the chat, and I see a question that says, will you send a certificate of completion? Oh, that's okay. That's just for the webinar. I don't actually see any other questions. Anybody have any other questions regarding the process to receive a license? Well, as Barry mentioned, we have many resources on our website under publications. A candidate information page has a plethora of information there on just basic information, IPAL, the ARE, links to various publications, links to the NCARB website that can be useful, such as the ARE guidelines, which we highly recommend candidates familiarize themselves with, the AXP guidelines as well. And there's information about, obviously the CSE and, reciprocity in other jurisdictions.
Marcus, question about whether the CSE exam is available online during the pandemic?
The exam is administered at test centers only. It is not like NCARB's soon to be online proctoring. Did that answer the question?
Okay. Mike, do we have any more questions or comments on either the California Architects Board requirements or the licensing requirements?
I think we addressed everything except the certificate of completion.
Okay. And Mike Wilson, do we have any other comments or questions?
Oh, Mike
Or Jane?
Mike had to leave to go on to another
Okay.
scheduled meeting.
All right, Jane, do we have any other comments or questions?
No, but to answer the question about the certificate of completion, um, due to just everything being online, you won't be able to get a certificate. However, you will still be able to get credit for this event. When registrants signed up on Eventbrite, there was an option to put in your AIA number. However, if you didn't add your AIA number, or if just in case you want to add it again, you can email your AIA number to us at info@aiaeb.org, EB as in East Bay. So again, if attendees think they don't remember if they included their AIA number and would like to get credits, to email us with your number at info@aiaeb.org. And I can message it at the chat too.
Okay. Well, that concludes our presentation. And Jane, thank you very much for your support.
Yes, thanks.
And Marcus, thank you.
Thank you, Barry.
And rest of the staff, Mike and Darren, thank you for participating. I appreciate that. And all of you other participants, we certainly appreciate you being on board. And if you have any other questions and concerns that come up after you've had a chance to think about what we've talked about, please contact the board, and we will get those questions answered for you.
Yes, you can always email the board at cab@dca.ca.gov.
Well, thank you very much. And that concludes our presentation.